Welcome to the Deep Dive, the place where we take these complex, really source-heavy stories and, well, we extract the essential knowledge you need to be thoroughly informed.
And our mission today is to navigate a case that is just defined by this astonishing contrast. It's almost unbelievable.
It really is. It serves as this chilling roadmap for how alleged extreme financial desperation can, drive premeditated crime.
And in the process, it exposes these critical vulnerabilities in our modern estate law.
We are diving into the Kouri Richins case, centered in Utah. We're looking at the aggravated murder charges, this dizzying financial collapse that prosecutors are pointing to as the motive.
And of course, the massive ongoing legal battle over her deceased husband's multi-million-dollar estate. It's a huge piece of this.
Okay, so let's unpack this whole thing, starting with the central paradox that really made this story explode in the first place.
Right.
You have Kouri Richins. She's a Utah real estate agent, a mother of three. And a year after her husband Eric's sudden death, she self-publishes a children's book.
A children's book, of all things. It's called Are You With Me?
Yeah, and it's designed to help her sons cope with the loss of their father. She's on local television in April 2023, publicly promoting this message of healing.
And then, just 30 days later, the entire narrative just flips completely.
Completely. In May 2023, she's arrested and charged with the aggravated murder of that same husband, Eric Richins.
The charge. A lethal fentanyl overdose. It's just a shocking turn.
The initial facts are genuinely startling, and they lay the foundation for this whole criminal case. Eric Richins, he owned a successful business, C&E Masonry. He died in March 2022.
And the autopsy revealed a lethal dose of fentanyl in his system. Now, when we say lethal, we need to be specific for you, the listener.
We do.
Toxicologists have reported cases where concentrations as low as 3 nanograms per milliliter, or NGML. That's enough to cause death in someone who isn't, a regular user.
And Eric Richins had 15 NGML in his system.
15.
That's 5 times the lethal amount.
It's an astronomical number. And that finding, that's the indisputable physical evidence at the core of this. Our sources detail this relentless financial pressure Kouri was under.
And the extensive secret measures Eric took to protect his estate before his death, which is a fascinating part of this.
It is. And then there's the extraordinary procedural drama that continues to define this trial, which, as of now, is set for 2026. This deep dive is going to ensure you understand every complex legal and financial mechanism that prosecutors allege drove Kouri's actions.
So to really understand the motive, we have to start at the beginning of their marriage, and specifically the financial guardrails that Eric tried to put in place.
Right. So Kouri was 23, Eric was 31 and previously divorced. They got married in June 2013.
And we learned from the sources that Eric's first divorce was reportedly not amicable.
Which, immediately flags caution.
Right.
You're thinking about property, about assets.
Exactly. And that caution manifested in a really critical document, a prenuptial agreement signed on their wedding day.
And this document is absolutely central to the entire case, not just the criminal charges, but this huge civil battle that's happening at the same time.
It was intended to establish clear, separate property rights to make sure that Eric's 50% ownership in his business, C&E Masonry, stayed his.
Even if marital funds were later used to support the company. That's pretty standard stuff.
It is. It's standard protective estate planning. But there was a single, pivotal, almost accidental clause in that prenup.
And the sources note the agreement wasn't perfectly tailored by an estate lawyer, maybe because it was presented so close to the wedding date.
And that clause stipulated that if Eric died while they were, and this is the key phrase, lawfully married, his entire interest in C&E Masonry would automatically transfer to Kouri.
That's the whole ballgame. That interest is valued by the sources at approximately $2 million.
So this single line just transforms. It goes from an ordinary inheritance provision into the prosecution's strongest evidence of a premeditated motive, the $2 million golden parachute.
And separately, in April 2019, Kouri starts her own real estate venture, Kouri Richins Realty, or KRR. She's flipping homes.
And at first, she showed some promise. Her friend, her marketing director, cited her success and dedication. Said she would often work on 3 houses at the same time.
The energy was there, the drive was clearly there, but the sources immediately start to show 2 completely contradictory narratives about the finances.
Exactly. On one side, you have Kouri's family, specifically her mother, Lisa Darden, who vigorously defends her.
And she insists that Eric was always fully aware of the family finances.
Right. They claim the couple sat down together every month to review bills, implying there couldn't have been any secret theft or, fraudulent use of his money.
But that is directly contradicted by the evidence from Eric's family and, of course, the prosecutors.
They paint a totally different picture.
A picture of Kouri as financially incompetent, maybe reckless. They state that by early 2022, her flipping business, KRR, was, and this is a quote, drowning in millions of dollars of debt.
And that she was operating in secret and fraudulently.
And that fundamental contradiction. Was Eric aware and participating? Or was Kouri operating this hidden collapsing scheme? That's what the jury will ultimately have to decide.
So the prosecution, they've gone to great lengths to establish that this fatal overdose wasn't just a one-off tragedy. They're trying to show a pattern.
They're arguing it was the successful third attempt on Eric's life, which demonstrates premeditation.
And where does this pattern supposedly begin?
It allegedly starts years earlier. Eric's family told investigators that during a previous trip to Greece, the exact timeline is a bit murky. Eric became violently ill after Kouri served him a drink.
So even years before his death, his inner circle already had some suspicions about her.
Exactly. It establishes a baseline of mistrust. And that brings us to the most direct evidence of attempted murder. Valentine's Day, February 14th, 2022, just weeks before Eric died.
Okay, what do prosecutors allege happened then?
They allege Kouri placed fentanyl into Eric's sandwich. But crucially, the sources link this timing to her alleged acquisition of the first batch of drugs from her housekeeper just a few days prior.
And Eric's reaction was, it was severe. Right.
Oh, it was cute and dramatic. He reportedly broke out in hives, had difficulty breathing, and alarmingly had to use his son's EpiPen before he just collapsed and slept for hours.
The defense tries to downplay this, though. They claim he was just not feeling well after a lunch they both shared.
But using an EpiPen, that suggests an anaphylactic, life-threatening crisis. Yeah. It's far beyond a simple case of food poisoning.
Right. And this is where the conversational evidence really strengthens the charge.
It does. The sources detailed this chilling comment Eric allegedly made to a friend after the incident. He confided that he believed his wife was actively trying to poison him.
How does the defense even counter verbal evidence like that? It shows Eric was actively afraid of Kouri.
They try to dismiss it as, subjective fear, suggesting he was stressed about the business and mistook an illness for an attack.
But for the prosecution, that statement is gold.
It's everything. It demonstrates Eric's mental state. It links Kouri's recent drug procurement with a severe, immediate physical reaction, and it's followed by his deep suspicion. It creates a narrative arc pointing directly to the final fatal act.
And that fatal act occurred on the night of March 3rd, leading into the 4th, 2022.
Right. Eric, Kouri, and Kouri's mother were reportedly celebrating a significant milestone. Kouri had just closed on the acquisition of that massive, unfinished Midway mansion.
The very mansion that we now know is at the core of her financial pressure.
Precisely. According to Kouri's statement to investigators, she made Eric a cocktail, a Moscow Mule, and then allegedly went to sleep with one of her sons who was having nightmares.
And her story is that she came back around 3 a.m. and found him unresponsive and then called 911.
Yes, but the scene detail from the responding paramedic is crucial to the timing. The paramedic noted upon arrival that Eric had been dead a while.
So that confirms a time lapse.
Significant one. It suggests Kouri wasn't present during the immediate onset of the overdose, which the prosecution argues allowed that massive dose of fentanyl, 5 times the lethal amount, to take full effect. That's what elevates it to aggravated murder.
The immediate aftermath of Eric's death is marked by this astonishing expediency and focus on financial transactions.
That's really something. Sources note that Kouri allegedly finalized the closing deal on that massive unfinished mansion the very day after Eric was pronounced dead.
That tells you everything about her priorities, if the prosecution's timeline is correct.
It does. Despite the tragedy, the crushing weight of that high-interest debt meant the business transaction took precedence over everything else.
And that urgency led to an immediate conflict over Eric's estate just 2 days later, March 6th, 2022.
This is when Eric's sister, Kouri Richins, and Kouri clashed violently at the family home.
Why was Amy there?
Amy had just learned she was named the trustee of Eric's living trust. This secret mechanism that Eric had set up to cut Kouri out of managing the assets. So Amy went to the house to secure a safe.
And this confrontation.
It's kind of physical.
Immediately. Kouri allegedly became enraged when she was informed about the trust and the fact that she was locked out of the estate.
And then what happened?
She then allegedly punched Amy in the face and neck.
Wow.
Yeah. Kouri was later charged with assault over this incident and pleaded no contest.
Even though her brother tried to downplay it, saying all they did was push.
Right, but the legal record shows the immediate ferocity of Kouri's reaction to losing control over Eric's assets. It just reinforces the motive that the prosecution is building.
And after all of this intense drama, a year later,
Yeah.
comes the ultimate public performance, the grief book.
March 2023, Kouri self-publishes Are You With Me?, aimed at helping her sons cope with their loss.
And then she spends April 2023 actively promoting this image of the heartbroken, resilient widow on local media. She's on shows like Good Things Utah. I just can't get over the timing. She's promoting a book about helping her children cope with the loss of their father just 30 days before she's arrested for killing him.
It's absolutely shocking. Did she genuinely believe she would get away with it, or was the book a strategic move,
Yeah.
to establish this narrative of innocence and public sympathy?
We can't know for sure, but the book has since been pulled from Amazon, and the sources note she was already planning a sequel.
A sequel.
Yeah. Mom, how far away is heaven? This public image versus the private allegations. I mean, that defines the unique horror of this case.
Okay, so if the state needs to prove premeditated murder, they have to prove motive. And the court documents detailing Kouri Richins' financial situation, they provide that explosive narrative.
The motive, according to the state, was the immediate critical need to access Eric's estate to prevent her company, Kouri Richins Realty, from totally collapsing.
Let's get into the granularity of this alleged financial crisis.
So the financial misappropriation, according to prosecutors, started way before Eric's death. We're talking 2019, 2020. The claim is that Kouri began siphoning money from Eric's accounts to prop up her house-flipping business.
And the first major violation they cite is the alleged use of a fraudulent power of attorney.
Right. A power of attorney, a POA, it grants you legal authority over someone else's assets. The prosecution alleges Kouri used a fraudulent one to execute a $250,000 credit deed of trust.
Which is basically a secondary mortgage?
Exactly. On the family home, securing a home equity line of credit, or AELOC.
And this is a crucial detail. A AELOC is supposed to be joint debt secured by the house. Forging a POA to do this means she was taking out a secret major loan against their biggest asset.
Without the co-owner's knowledge or signature. She then allegedly withdrew the entire $250,000 to fund her business, KRR.
The estate's separate civil lawsuit quantifies this even further. They claim Kouri stole another $200,000 directly from bank accounts and charged $30,000 on his credit cards by 2020.
And she reportedly told Eric she would repay the funds, leading him to believe the debt was cleared. But the court documents show it absolutely was not.
So this hidden debt spiral, it just gets worse. It accelerates exponentially in the 5 months leading up to March 2022.
The numbers are just staggering. In that period, KRR generated a total revenue of only $170,000.
Okay, $170K in revenue. But what about her debt payments?
The monthly debt service, just the payments required to keep the loans current, exceeded $250,000.
Wait, a month?
Per month.
So that's a negative cash flow situation that is completely unsustainable. She was losing $80,000 every single month just to service the debt. That's not even including operating expenses.
Right. The charges indicate Kouri allegedly resorted to borrowing from over 25 different lenders during this period, just constantly shuffling high-interest money around in a desperate attempt to stay liquid.
And this brings us to the crucial final push in the fall of 2021. In November, Kouri allegedly purchased 3 additional properties.
And to do this, she used hard money loans. For you listening, hard money loans are typically ultra-short-term, asset-based financing. Flippers use them.
But they come with cripplingly high interest rates.
Crippling, sometimes exceeding 15 or 20%. This was a 5-alarm fire, financially speaking.
So she added $1.1 million in extremely high-interest debt, even though the sources allege she was already defaulting or delinquent on her existing loans.
She wasn't just drowning. She was paying a massive premium just to stay afloat for a few more weeks.
And then comes the final immense gamble, the Midway Mansion.
December 2021. Kouri contracts to buy this unfinished multi-million-dollar property, leveraging $2.9 million in more high-interest debt due in just 6 months.
And prosecutors argue she had no ability to pay it, refinance it, or even renovate the property to flip it for a profit.
Which highlights the true urgency of Eric's death. On the day he died, KRR owed hard money lenders at least $1.8 million.
The day after his death, the day Kouri was closing on the mansion, that debt load jumped to nearly $5 million.
The prosecution alleges she was on the precipice of total financial collapse. The only immediate route to survival was triggering that $2 million prenup clause and accessing his overall $5 million estate.
What's so fascinating here is that Eric wasn't passive in all this. While Kouri was allegedly accelerating her debt, Eric was implementing these secret, extraordinary legal measures to protect himself.
And his sons. He was really trying to shield them.
Right. This action begins in November 2020. Prosecutors allege Eric discovered Kouri's misappropriation of funds, probably that HLOC fraud.
And he immediately sought counsel from an estate planning lawyer, Crystal Bowman Carter, to establish the Kouri Richins Living Trust.
A trust is more powerful than a simple will, right? Because it can dictate how assets are managed right away.
And it circumvents the lengthy public probate process. Bowman Carter outlined Eric's two clear objectives for the trust.
What were they?
First, short-term protection from fairly recently discovered and ongoing abuse and misuse of his finances by his wife, Kouri Richins.
And second,
Long-term protection for his three sons, by ensuring Kouri would never be in a position to manage his property after his death.
that is just explicit legal intent. He named his sister, Kouri Richins Benson, as the trustee, and critically, Kouri was never informed of the trust's existence.
He was building a secret legal wall against her.
Beyond the trust, the life insurance policies became this huge arena of conflict. Kouri is alleged to have purchased 4 different policies between 2015 and 2017, totaling over $1.9 million.
But the key moment of attempted fraud, according to the prosecution, happened months before he died, January 1st, 2022.
What happened then?
Prosecutors allege Kouri surreptitiously and without authorization changed the beneficiary for Eric's $2 million life insurance policy to herself. This is where the insurance fraud charges come from.
But Eric found out.
He did. He received a notification of the change. He discovered the attempt and immediately reversed it, changing the beneficiary back to his business partner.
So this action proves that Eric was acutely aware and actively defending his estate from Kouri in the months right before his death.
It does. It further supports the prosecution's motive narrative that she had to eliminate him before he could put even more legal obstacles in her way.
Let's shift focus now to the specifics of the criminal charges. The prosecution's case relies so heavily on tying Kouri to that lethal fentanyl dose.
And they're using witness testimony to establish procurement and digital forensics to establish intent.
So the physical link to the drugs, it relies almost entirely on the testimony of CL, right, Kouri's housekeeper.
Yes, who is also a convicted felon, which is a major point for the defense. Prosecutors allege Kouri asked CL to get her fentanyl.
And she referred to it as some of the Michael Jackson stuff.
An unbelievable detail. It's a reference to the drug responsible for his death. CL reportedly sold Kouri between 50 and 30 fentanyl pills for $900 in February 2022.
Right before the alleged Valentine's Day poisoning attempt.
Exactly. And the charges also reflect testimony that Kouri had allegedly asked her handyman for both fentanyl and propofol weeks before Eric's death. It suggests she was widely seeking illicit substances.
The digital records reinforce this communication timeline, even though the messages themselves are missing.
Right. Phone records show texts between Kouri and CL from January 2nd until shortly after Eric's death were systematically deleted from Kouri's phone.
Which the prosecution interprets as intentional destruction of evidence.
Of course. And this is where the Google search history comes in, which the prosecution has presented as this irrefutable proof of intent and planning.
And these searches took place after Eric's death.
Yes. The searches included jaw-dropping phrases like, luxury prisons for the rich in America.
You can't make this stuff up. And also, what is a lethal dose of fentanyl?
Other searches detail her panic and her desire for control. Can FBI find deleted messages? Will life insurance still pay if death certificate says pending? And how to permanently delete information from an iPhone remotely.
She also searched for her own net worth and details about her husband's family's connections to the police. It suggests she was actively preparing for legal scrutiny.
Searching for luxury prisons for the rich in America. I mean, the level of entitlement there is just stunning.
Does that signal sophisticated planning or just utter panic?
The defense says panic, but the prosecution uses the sheer variety of searches, lethal dose, deleting data, securing insurance money, escaping to a luxury prison, to establish this clear pattern of post-homicide concern over the financial and legal fallout.
The defense has a clear counter-narrative, though, and they have to use it forcefully because the physical evidence of procurement is circumstantial.
That's right. Defense attorney Sky Lazaro argued the Google searches were simply innocent questions Kouri had about the accusations after Eric's death. She was being questioned, so of course she would research the allegations.
And they also point to a major evidentiary hole.
A huge one. Law enforcement never found or seized any fentanyl, propofol, or any other illicit drugs from the Richins' home.
So the defense argues the state's case relies entirely on circumstantial digital evidence and the testimony of potentially compromised witnesses.
Like CL, the convicted felon. That's their main line of attack.
The legal landscape of this case has been incredibly dynamic, with shifting charges and constant fights over witness credibility.
The charges have evolved significantly. By October 2025, the Summit County Attorney's Office filed amended charges. Kouri still faces aggravated murder and attempted aggravated murder.
But they dropped the drug distribution charges and some of the original mortgage fraud counts.
And in their place, she now faces 2 counts of insurance fraud and 1 count of forgery.
Why drop the drug distribution charges? Was that a tactical retreat because of the weak witness testimony?
It was likely tactical. It signals the prosecution realized relying on the word of a convicted felon, CL, and their alleged supplier, Crozier, who recanted. It was just too risky for a direct drug charge.
Especially when the murder charge itself encompasses the use of the drug.
Exactly. So instead, they focused heavily on the financial crimes as the undeniable motive.
And that focus intensified dramatically in June 2025.
It did. Kouri was hit with 26 additional charges related to financial crimes, mortgage fraud, money laundering, forgery, issuing bad checks.
A pattern of unlawful activity. It's a massive escalation of the white-collar component.
And this sudden push, as the defense called it, to file dozens of fraud charges 2 years after Eric's death, was seized upon by the defense team.
They argued that it underscores the weakness of the state's pending murder charges,
suggesting the fraud charges are just a contingency plan if the core murder case fails to secure a conviction.
But legally, does filing those new fraud charges 2 years later actually weaken the core murder case?
I would argue it powerfully reinforces the motive. While they might be difficult to prosecute on their own, they build this overwhelming narrative of a defendant who is utterly desperate and willing to engage in continuous illegal activity to secure funds.
The sheer volume of fraud charges makes the murder look like the final logical step in a long pattern of illegal behavior.
Precisely. And meanwhile, the foundation of that murder case faced a huge threat from a witness recantation.
Right. This is Robert Crozier, the man who allegedly supplied the fentanyl to CL, the housekeeper.
Yes. Crozier reportedly recanted his claim that he ever sold fentanyl to Lober, who is CL. This is massive because it breaks the alleged chain of custody linking the fentanyl in Eric's body back to Kouri.
So the defense immediately argued that prosecutors had known about Crozier's recantation since April, but knowingly withheld this exculpatory evidence.
Exculpatory evidence being anything that might prove the defendant's innocence, which prosecutors are legally bound to share.
And the defense attorneys argued forcefully that if the state cannot link the fentanyl to Kouri,
then the state has no case. They even described the recantation as throwing a grenade into the middle of it.
the courtroom atmosphere is just so adversarial, filled with these dramatic counterclaims.
Like when Kouri was accused of witness tampering. This was related to an unsent letter, the Walk the Dog letter, found in her jail cell.
What was in the Walk the Dog letter?
Well, the defense argued it was just innocent correspondence. But prosecutors claimed the letter contained instructions for Kouri's brother to lie or coordinate testimony.
So it allegedly outlined specific steps for him to follow.
Very detailed steps, including asking him to retrieve an object that was purportedly hidden in her family home. The prosecution believes this was the murder weapon or remaining drugs, and instructing him on what to say about the drug allegations.
And even though it was unsent, it was used as evidence of flight risk and consciousness of guilt.
And then on the flip side, Kouri filed a motion accusing Eric's family trust of paying prosecution witnesses in the murder case.
This intense high-stakes battle over credibility and conduct just illustrates the ferocity of this whole pretrial period.
It's incredible. And while the criminal case progresses toward 2026, a parallel, equally ferocious battle is ongoing in the civil courts.
This is all about whether Kouri will profit from Eric's death, regardless of the criminal outcome.
And Kouri was the one who initiated the civil litigation. She's relying on that critical $2 million clause in the 2013 prenup.
She's arguing the prenup mandates she receive Eric's business interests because they were still lawfully married when he died.
Her position is purely contractual. She is arguing that unless and until she is convicted, the contract stands.
But the estate managed by Eric's sister Kouri Richins Benson, responded swiftly and aggressively.
In June 2023, the estate filed a wrongful death lawsuit against Kouri, seeking over $13 million in damages.
And that total includes damages for Eric's lost future earnings, emotional distress for his kids, and punitive damages.
Right. And the key legal principle governing whether Kouri can claim that $2 million hinges entirely on the Utah Slayer statute.
For you listening who don't follow estate law, the name is pretty descriptive. Utah Code, Section 752803.
This statute is designed for exactly this heinous scenario. It prevents a convicted murderer, the slayer, from retaining a property interest in their victim's estate.
It legally treats the murderer as if they had predeceased the victim.
Which is the key. If Kouri is convicted, the statute dictates that she died before Eric, instantly nullifying her contractual claim under the prenup.
So, if Kouri is convicted of aggravated murder, the prenup clause is voided by the Slayer statute, and she can't collect the $2 million.
But if she is acquitted, the contractual language remains in effect, giving her a very strong claim to that money. It shows just how intertwined the civil and criminal outcomes are.
And beyond the $13 million in damages, the estate made another powerful demand.
They did. They're seeking all revenues generated from the sales of Kouri's children's book, Are You With Me?
And an injunction to bar future sales.
Arguing the book misuses Eric's name and likeness without the estate's consent. It's a direct attempt to ensure Kouri cannot profit in any way, shape, or form from the public notoriety surrounding this alleged crime.
This high-profile civil conflict, where the alleged killer was suing the deceased husband's estate for millions, was so unprecedented in Utah that it prompted an immediate response from the state legislature.
That's right. Rep. Brett Garner, a Democrat from Salt Lake City and a childhood friend of Kouri Richins, introduced Bill HB 569. It was specifically to address the loophole exploited by the prenup claim.
Garner recognized that under current law, the Slayer statute only applies after a conviction, leaving this window open for legal maneuvering in the meantime.
The core of HB 569 is to give a judge the discretionary authority to nullify or amend an inheritance or prenup that benefits a perpetrator after they have been convicted of murdering a spouse or family member.
It's all about giving the court flexibility.
Garner noted the absurdity of the current situation. He said that there's nothing stopping her from doing that, referring to the civil suit, while Kouri is incarcerated and awaiting trial. HB 569 closes that gap.
So the implications are profound. If the bill passes and Kouri Richins is convicted in 2026, a judge would have the specific legal power to set aside the prenup payout she is suing for,
ensuring she cannot profit off that act of violence, as the sponsor stated. This legislative reaction just crystallizes the unique legal challenge this case presents to Utah's estate and contract laws.
This case has just been defined by these complex procedural disputes, especially regarding Kouri's incarceration status and the intense battle over where and how the jury will be selected.
Kouri Richins was initially denied bail right after her arrest in June 2023. She has tried to get released multiple times November 2023, again in November 2024, but the judge has repeatedly cited the substantial evidence against her.
And what specifically constitutes substantial evidence in the eyes of the judge in these pretrial hearings?
Well, the evidence presented by the prosecution is designed to meet that high burden. It included the discovery of the high fentanyl dose, the specific testimonies about the alleged past poisoning attempts.
In Greece and on Valentine's Day.
Right. The detailed digital search history indicating preparation for flight and legal fallout, and the testimony regarding the physical altercation Kouri had with Eric's sister.
Suggesting violent intent and a flight risk.
All of it together convinced the judge that Kouri was both a flight risk and a danger to the community, so she needs to stay in detention.
We also have these fascinating details about Kouri's demeanor during the investigation.
We do. Detective Jeff O'Driscoll, the lead investigator, testified that during initial interviews, Kouri appeared cheery, open, and happy to talk, a detail many observers found unsettling.
But the detective also noted a brief moment of apparent emotion at the detention hearing.
When he described the scene of the death, specifically finding Eric's body cold to the touch. At that point, Kouri reportedly appeared to cry.
This stark contrast in her reported behavior from cheery to emotional only adds to the public perception of this enigmatic defendant.
And due to the complexity of the case, the trial date has been set far into the future, February 2026.
And given the massive national and local media attention, the defense argued intensely that finding an impartial jury in Summit County, a smaller, less diverse area, would be nearly impossible.
So the defense filed a crucial motion asking for a change of venue, or at least an expansion of the jury pool, the veneer, to include neighboring Salt Lake County.
The challenge was that media saturation had poisoned the smaller jury pool.
Right. But 3rd District Judge Richard Mrazek denied the motion to move the trial. He acknowledged the media situation, stating the extensive coverage was an indictment of those media outlets and our current media culture.
But he concluded it didn't meet the stringent legal standards required to move the proceedings.
He found that enough potential jurors had either not heard of the specifics or hadn't yet formed a fixed opinion. He weighed the severity of the charges against other factors and decided to keep it in Summit County.
And then the procedural drama escalated all the way to the Utah Supreme Court in early 2025.
In an unusual move, both the prosecution and the defense jointly appealed several procedural decisions. Specifically, the denial of an expanded jury veneer and the request for in-person jury selection.
So the Supreme Court essentially slapped down both sides. Why is Utah law so rigid on keeping the jury pool tied only to the county of the trial?
The Supreme Court ruling meticulously detailed that Utah law, specifically the Jury and Witness Act, mandates that jurors must be selected from a single county, the one where the trial is held.
So the court found that the legislative intent required this strict single-county approach.
And they dismissed arguments that the media attention warranted creating a multi-county veneer. The court also ruled the intense media attention didn't constitute the extraordinary circumstances necessary to override the standard order for virtual jury selection.
That's a decisive ruling. It sets the hard boundaries for the entire trial, single-county jury pool, virtual selection process, and the trial remains in Summit County starting in February 2026. The stage is set.
And it's going to be a trial where media influence and local opinion will be scrutinized intensely during that jury selection process.
What stands out to me most, and what we hope you now fully understand, is how these seemingly disparate threads, the murder, the financial ruin, the estate battle, are so tightly wound together.
They form a singular narrative of motive and desperation. It's the tight connection between the alleged financial ruin of Kouri Richins Realty, where debt ballooned to $5 million,
and the immediate attempt to access Eric's estate through that single critical loophole in the prenup.
The motive is as financial as it is personal.
And then you have that massive civil battle where Kouri's $2 million claim hinges entirely on whether she is criminally convicted.
Which would activate the Utah Slayer statute and prevent her from profiting. And that civil case, in turn, spurred the Utah legislature to propose HB 569, a new law designed specifically to prevent this from happening again.
The sheer volume of evidence and counter-evidence, from the incriminating digital searches to the witness recantation that the defense claims throws a grenade into the prosecution's case.
It just shows this will be one of the most intensely contested Utah trials in recent memory, all playing out under these strict procedural rules set by the state's highest court.
And we keep coming back to the most unique and disturbing detail, the book. Are you with me? Written by the accused about coping with the exact loss she is accused of causing.
This dynamic of an author's work becoming dark or deeply disturbing based on later shocking revelations about their life. We sometimes see that in literary history.
The sources noted examples, like certain fantasy writers whose works were reread and reevaluated through the lens of their later personal scandals.
But this case is distinct. The Grief book wasn't an earlier work that was recontextualized.
No, it was a direct, calculated performance created immediately before the allegations became public. It forces the reader and the court to constantly reevaluate the text in light of the criminal charges.
Exactly. And we are left with a final provocative thought for you to consider. Does the text itself, written about the tragedy caused by the author's own alleged actions, function not just as an artifact of the defense's narrative,
but as a chilling commentary on the nature of guilt, performance, and the ultimate desperate attempt to control the public narrative, even from a jail cell?
That unique intersection of true crime and public performance is something the eventual jury will have to struggle with. Thank you for joining us on this deep dive.